Hi, everyone. I'm Bob Babcock. I'm a partner in the Tully Rinckey Criminal Practice Group here in the Capital Region office. Today, we're going to talk about firearms. Not so much the fun stuff like the defaced firearms or modified. Today, we're actually just going to talk about licensing, eligibility, types of licenses, things of that nature. It's a very fast-moving, ever-changing area of the law here in New York. So we're going to go over the highlights and hopefully give you a good foundation for what the law is in New York. So here we have the section that sets forth the licenses to carry, possess, repair, and dispose of firearms. Big thing here is eligibility. We talk a lot, if you're with Tully Rinckey or you work with us, you'll hear the acronym BLUF. Quite often. BLUF stands for bottom line up front. And that's what I'm going to try to do with this presentation, give you the bottom line up front so you can take away the main points and get what you really need from this presentation. So here we go. Eligibility. Highlights are you must get your license issued by a licensing officer, and there are several requirements in doing so. Number one, you have to submit to an investigation. That investigation requires that you fill out an application and make all statements in that application truthfully. The licensing officer is going to check to see if all those statements that you've made in terms of your application for that license to carry are accurate. Now, what are the actual requirements? Well, number one, you need to be 21 years old. And if you were honorably discharged from the United States Army, Navy, Marine Corps, no such age restriction shall apply. So if you're 19 or 20 and you're honorably discharged from the military, you don't need to be 21. Everybody else, you have to be 21 years of age. Good moral character. What does that mean? Put simply, you don't have any acts, whether they be criminal, wrongful, or anything else, that would show that your moral character has some issues with judgment, has some issues with being entrusted with a weapon. Did you ever make any statements or have any actions that would be interpreted as presenting a danger to yourself or a danger to someone else? So you need to be of good moral character. You cannot be convicted anywhere of a felony or a serious offense. And you can't be subject to an outstanding warrant for arrest. You cannot have a felony conviction. I know a lot of folks have said, well, if my felony conviction is for this or for that, just assume that if you have a felony conviction, you're not going to get a license to carry in the state of New York. Also, the serious offense category is something that we need to be aware of because it's not a felony, but it's a serious offense that relates to someone maybe making a threat to someone or themselves. Again, not a fugitive from justice. You're not out on the run. And this is an important section to keep in mind. It's a little bit of a gray area. Who is not an unlawful user of or addicted to any controlled substance? So you can't be an unlawful user. You can't be addicted. If you have any of those records in your history, that will be a possible bar to receiving a license to carry. Now, determining whether or not someone is an unlawful user, that's based on their statements to the licensing authority. Addicted to a controlled substance, that might be in some medical records somewhere, but very important to note that. All right, your eligibility, who is eligible just out of the gate, right? You're not illegally or unlawfully in the United States. Enough said about that point. Not been admitted to the United States under a non-immigrant visa, subject to the exception in 18 United States Code 922. Pretty straightforward. You've not been discharged from the armed forces under a dishonorable condition. So if you have been in the military and you have not been discharged for a dishonorable condition, that is a criteria. You are a citizen of the United States and you have not renounced your citizenship. If you're a sovereign citizen, or if you say, yeah, I'm a citizen of the US, but I recognize my Somalian brothers and that's the way I go, that could be a bar to you receiving a license because you're saying I'm not subject to the laws of the United States. I renounce my citizenship. Stated whether you have ever suffered a mental illness. Another gray area. How does How do you even categorize that or determine that? Well, one, you're going to be asked, have you ever submitted yourself voluntarily into any kind of psychological evaluation for any purpose? And then obviously, two, have you ever been committed to, which is the next bullet, have you ever been involuntarily committed to a facility under the jurisdiction of an offense of the Department of Mental Hygiene, which is just language in New York, that basically says if any agency, government official program, mental health program, if the government has placed you into an examination of your mental health against your will involuntarily, that's going to be a preclusion to getting a license. If you have not had a license revoked, you're not under suspension or in an ineligibility order pursuant to the provisions of 530.14 of the Criminal Procedure Law or 842 of a Family Court Act. So remember, these cover not just criminal matters, these also bleed it over into civil matters, family court, hospitals. You say to somebody that you're not feeling well and you're feeling suicidal, the ambulance people come, they do an evaluation and they determine you should go in for a period of time. A police officer didn't put you in. A medical official put you in, but you still went in involuntarily. That's something that would be a possible preclusion to getting a license to carry. This is an exception in the County of Westchester. This is eligibility again. If you successfully completed a firearm safety course and as evidenced by a certificate of completion, and it's been affirmed under the instructor, that's something you need to do in Westchester County. However, there are exceptions. If you're honorably discharged from the United States military, that is an exception. If you were licensed to possess a pistol or revolver prior to the effective date of this paragraph, you don't need to complete the firearm safety course because it's come in after you were already certified to carry that weapon. So obviously, first exception, you're honorably discharged. You've been trained by the military to carry a weapon. You've been honorably discharged. You don't need to go through the safety course. Second one is obviously you were already licensed prior to. And then the third bullet just says persons applying for a license under paragraph F of subdivision 2 on or after the effective date of the chapter. So they're basically saying you have completed the training required under subdivision 19 of this section for such license. So if you've previously done everything you're supposed to do, you do not need to now come back and do it again. Now, this is an important bullet that I think maybe escapes a lot of folks. Who has not had a guardian appointed for him or her pursuant to any provision of state law based on a determination that as a result of marks of normal intelligence, mental illness, incapacity, condition, or disease, he or she lacks the mental capacity to contract or manage his or own affairs. That's a little bit different. Now we're not just talking about a danger, a threat to yourself or to someone else. We're talking about actual determination that you have subnormal intelligence. Tough standard in the criminal law arena, because I'm not sure how that would be confirmed or measured, but it is a category that the licensing authority can look at and say, we don't think you have the mental competency to actually have a license to carry a firearm. Again, eligibility, this is all still under the bluff. The bottom line up front, we're still just talking about who is even eligible to apply for a license to carry in New York. For a license issued under this paragraph, the applicant has not been convicted within the 5 years of the date of the application of any of the following. These are a little bit surprising to some folks who don't practice criminal law. You cannot be convicted within the last 5 years of 3 crimes. Well, more than 3 crimes, but these 3 stand out. Assault in the 3rd degree. Assault in the 3rd degree is a relatively minor charge in New York State. I mean, I've had a case as early as today where someone threw an empty can at someone and hit him in the head, and it was an assault third, right? Very small case. Now, granted, you're not going to be convicted of an assault. It's probably going to be something much higher that came down to that assault. But keep in mind, an assault in the 3rd degree within the last 5 years is a preclusion to getting a license to carry in New York State. Misdemeanor driving while intoxicated, as defined under 1192. So if you get the misdemeanor, not the violation is the 1192.3. No, 1192.3 is common law. And 1192.1 would in fact be the violation. That's not what they're talking about. If you do take a misdemeanor, the unclassified misdemeanor, which is the 1192 1 or 2 or 3, you get the misdemeanor charge, you're going to be precluded on that. You will not be precluded if you just get the violation. Obviously, if you have multiples, that's another factor. So remember, DWI can be a preclusion. Also, menacing, 12015 of this chapter. That's an obvious one. If you menace somebody, they're not going to want you to have a license to carry a weapon because you may now menace that person with a weapon. So that's going to be a preclusion. Again, we talked a little bit about a lot of these requirements. You have to meet in person with the licensing officer for the interview. Why is that important? Because they're going to sit across from you and they're going to assess your character. They're going to sit there and they're going to try and ask you questions that are going to ascertain whether or not you are a normal individual who does not have any issues in terms of your mental health or anger issues or things of that nature. So they want to sit down across from the table with you, talk to you, look you in the eye, get your reaction to the questions that they ask. You're also going to have to provide a lot of information, the names and contact information for your current spouse, your domestic partner, any other adults that are living in the house with you, any other adult children, any other minor children that are living in the residence with you. Again, common sense. Why would they want this? They want to know who's going to be in the house of the individual who has a license to carry a firearm, because obviously that firearm will likely be stored in that house. They want to know who else may have access to it. The names and contact information of no less than 4 character references. I think we can all understand why this is important. They want to make sure there's 4 other individuals out there walking around in the world that know you well enough, or your client who's applying for the license to carry, to say that, yeah, this guy or gal is they're above board. There's no issues. I recommend them. I don't have any concerns. You got to have 4 of those. Make sure they're not somebody who has a felony record. Believe it or not, we have seen that. Not that it's a bar, but it's not something that's really a great thing to do. Try to put non-criminal record people on your list of contacts for moral character. Now let's see, we've got certificate of completion of the training required in subdivision 19 of this section. The training requirements are set forth. We know that you have to go through the firearms training course with a licensed instructor. However, we did talk about the exceptions to those if you're military, or some of those other exceptions apply. Tell your clients, though, that you're going to have to prove, you're going to have to show that you have a certificate of completion of the training required. Now, some firearms instructors will make the training a little bit more onerous. Some firearms instructors will not. They'll meet you at the range, you go through a few, basics, and they'll be satisfied and you'll get that certificate. But those can vary in terms of the degree of detail. A list of former and current social media accounts of the applicant from the past 3 years to confirm the information regarding the applicant's character. Okay, why was this a consideration and why is this put into the process? Well, if we're going to have a beef with someone, if we do have an issue with our employer or our neighbor or our family member, chances are, if we have a social media account, we might see something there. We might see that, I'm just gonna get my gun and we want to check those social media accounts. We want to see, one, are you in any organizations that promote violence? Are you in an organization that may promote lawlessness or some kind of overthrowing of the government, things of that nature? But more specifically, I think the real reason for that is because they want to have an opportunity to review what you have said in the privacy of your own home or wherever on social media that conveys your true thoughts. Did you make any threats, or did you say anything a little bit squirrely that people might look at and say, is this somebody we really want having a license to carry? Okay. And then the last bullet is another one that should jump out to all the attorneys online here, and that's such other information required by the licensing officer that is reasonably necessary and related to the review of the licensing application. A lot of leeway there, right? A lot of general terms. So the licensing officer, as we'll see in a minute, has a lot of leeway, a lot of discretion in making this determination. And they can pretty much say, you know what, I'd like to see your last evaluation, or something to that effect, where it may not check any of these specific boxes, But at the end of the day, they have the authority to say, I think it's necessary, it's reasonably necessary to my review of your application. Okay, these are still eligibility, but in terms of the licenses, we're not going to go into a lot of detail there. The business of a gunsmith or dealer in firearms, that's kind of a unique category. Most of your clients are not going to be applying for gunsmith or dealers, but if they are, again, very similar regs apply. They must be a citizen of the United States. They must be 21 years or older, and they must maintain their place of business for that purpose within the city or county where the license was issued. So if your license is issued by Rensselaer County, you can't then open up your gunsmith shop up in Warren County by Lake George. It has to be consistent with the county or city that's issuing your license. That's where your business needs to be located because it's regulated in that location. Also, if you're in business with 2 or 3 people, all of them have to meet the requirements. It's not sufficient where sometimes liquor license can be in one person's name. The other people can just be owners, employees, things of that nature. If it's in the gunsmith area, it has to be that everybody is compliant with the law. So each member shall comply with the requirements of this subdivision. Serious offense. We talked a little bit about this. An offense in any jurisdiction or the form of penal law that includes all the essential elements of a serious offense as defined by subdivision 17 of section 265 of this chapter. So you can kind of go through and take a look at that and see exactly what constitutes a serious offense. Again, the licensing official has a lot of discretion. Something that you might think is relatively low level, not a serious offense, for purposes of reviewing an individual's fitness for carrying a license to carry a pistol or firearm in public where no one knows that individual has a license to carry and has a permit or has a pistol on them. They're going to look at what they consider a serious offense. And those are going to go into things that are not violent, don't relate to guns. That could be cashing a bad check. That could be impersonating someone. That could be filing a false police report. Crimes of moral turpitude can be a serious offense if the officer or the official looking at it says, I want to know a little bit more about this. Tell me a little bit more what happened here. Serious offense can be whatever the licensing officer believes it is. Advocate to your clients to be truthful. Explain anything that's happened that may constitute a serious offense. Do not try to cut corners. Do not try and minimize, obviously, just as if you're talking to a probation officer or someone else who's trying to assess whether or not you understand that what you did was serious. That would be my best advice on the serious offense portion of this. So this is basically types of licenses, again, still eligibility, but now we're getting into what, if you are eligible, you go through all of the requirements, you've passed, what kind of license are you eligible to receive? So obviously a license for a gunsmith or dealer in firearms shall be issued to engage in that business, which we just talked about. If you're going to be in the business selling, repairing, disposing of firearms, you're going to need to have that dealer license. But a license for a semi-automatic rifle other than an assault weapon or a disguised gun shall be issued to purchase or take possession of such a semi-automatic rifle when such transfer of ownership occurs on or after the effective date of chapter 212 of the laws of this subdivision. So basically, a license for a pistol or revolver other than an assault weapon shall be issued to have and possess in the dwelling by a householder, homeowner, home renter. So you're in your home, that's where you're going to possess it, that's where you're going to have it. It's not going to leave, it's only for in your house. Have and possess in your place of business, my merchant or storekeeper. So that could be somebody in a liquor store, or somebody in a jewelry store who has that weapon in their place of business as a merchant or a storekeeper. Have and carry concealed while so employed by a messenger employed by a banking or financial institution. You're going to be running financial documents and money around there. That's an exception, obviously. You can have and carry concealed weapon in that role. Have and carry concealed by a justice of the Supreme Court. in the first or second judicial departments or by a judge of the New York City Civil Court or New York City Criminal Court. Again, pretty self-explanatory. We want our justices to be protected. We want certainly our judges and justices in the city of New York to be protected. So those are also some other areas of types of licenses that can be issued. Okay, so we're continuing on the types of licenses. Now, have and carry concealed while so employed by a regular employee of an institution of the state. What are we talking about here? This is corrections officers. These are individuals who have to have control over, transport, supervise, house individuals who are either accused of a crime or held as witnesses in criminal cases. So basically, that is a carve out. It's a peace officer who is involved in the care of and the supervision of either inmates or individuals who are accused of or witnesses in criminal trials. So that's a special carve out. Have and carry concealed without regard to employment or place possession subject to the restrictions of the state. So that's what we're talking about. To carry a concealed weapon on your person without regard to what you do for a living. Now, those are going to be subject to a bunch of restrictions we're going to get to. But basically, that's the big category. That's the license to carry a weapon on your person. To have, possess, collect, and carry antique pistols, which are defined as all those follows. I won't waste your time with all of this. Think Flintstones, think the old-timey days, right? Any single shot muzzle loading pistol, matchlock, flintlock, all that stuff. If you have weapons that are old before 1898, that's automatically by definition an antique. So they can either fit into that antique caveat either by the type of weapon they are or when they were actually manufactured, and which are not designed for using rimfire or conventional centerfire fixed ammunition. Okay, any replica of any pistol described in the clause hereof, if such replica is not designed or redesigned for using rimfire or conventional centerfire fixed ammunition. Please, please, please make the distinction between replica and modified or ghost guns or anything like that. That's not what they're referring to here. They're just referring to replicas, again, more in that antique vein, not using certain kinds of fire, no longer manufactured in the United States in terms of that kind of ammunition. Another very unique category. Not going to see that very often. Okay, so here we go. This is where we get into the criminal aspect of this. Okay, so in New York, it is a crime to possess a firearm without a license. That could actually be a period, whether or not inside or outside the home. If you don't have a license and you have a firearm in your house and the cops come and find it, you're going to be charged. So don't think that, oh, the Second Amendment says I have the right to bear arms, and as long as I keep it in my house for my own safety, I don't need a license. Yeah, you do. You do. So an individual who wants to carry a firearm outside his home may obtain an unrestricted license to have and carry a concealed pistol or revolver if he can prove that proper cause exists for doing so. Proper cause has gotten a lot of attention by the Second Amendment advocates, the lawyers for the Second Amendment folks, lawyers on both sides, lawyers for the government. What the heck are we talking about with where proper cause exists? I thought the Second Amendment said if I live in the United States and I'm a citizen, the Second Amendment allows me to have a firearm. Well, in New York, there's a proper cause requirement, and let's take a look at it. This is all the Bruin case, which has gone up on appeal. Some parts were upheld, some parts were overturned. These are the highlights of this case. This is a lot of background, obviously. So the case held that the proper cause requirement violates the 14th Amendment. We understand why they would say that. The common law offenses, they look back and they say, well, during the colonial and founding periods, the common law offenses of affray are going armed to the terror of the people. They continued to put limits on firearms in the antebellum period, but this is the important thing to remember. No evidence indicating these common law limitations impaired the right of the general population to peaceably carry. So although they were putting some restrictions on, it wasn't something that said, hey, this is going to limit the right of the people to carry in New York State. So now we look to, in the early to mid 19th century, some states began enacting laws that prescribe the concealed carry of pistol permits and other small weapons. That's when they started to say, okay, if you're going to carry a firearm and you're going to carry it in a concealed manner, we should put some regulations on them. We don't want everybody walking around with a weapon tucked in their boot. We don't know about it. That's going to cause mayhem. So they're starting now, early to mid 19th century. Some states are starting to put into some regulations about carrying small weapons and hidden weapons, weapons that are secreted somewhere on your body and your person, things of that nature. Okay, surety states, you have to post a bond, basically. So that was them saying back in the day that if you're going to be allowed to carry a gun on your person in a concealed manner, you're going to have to put some money up because we're afraid you might go shoot up the saloon or shoot Ned's horse. So we're going to ask you to put some money up first. Put up a bond to make sure that any damage you reasonably cause to fear an injury or a breach of peace, those kinds of things you had to show. I have a reason to carry. New York presumes that individuals have no public carry right without showing a heightened need. The surety states presume that the individuals had a right to public carry that could be burdened only if another could make out a specific showing of reasonable cause to fear an injury or breach of peace. So the other party who would say, hey, I think he's going to come after me with this gun, that's where the sureties would come forward and they'd say, okay, we need you to post a bond. So a lot of history there, not really necessary, just a little background in terms of how we got to putting some regulations on individuals' rights to carry a concealed weapon. So no New York statute defines proper cause. Of course not. Why would they define proper cause for all of us, right? So proper cause is going to be up to the discretion of the licensing official. And they're going to have quite a bit of discretion in determining what is a showing of proper cause. New York's courts have held that an applicant shows proper cause if he can demonstrate a special need for self-protection, distinguished from that of the general community. What does that mean? Well, let's say you're somebody who works in something that's pretty rough. Let's get away from the government job, but you carry a lot of cash home because you're a jeweler or a liquor store owner, something of that nature. Or maybe you're in a profession that deals with transporting dangerous or valuable material, something like that. You have to show that, listen, it's not just because I'm a corrections officer. It's not just because I'm a judge. It's because I do something that's a little bit weird that exposes me to a need for self-protection that's different than Joe Lunchbox, right? My situation in terms of my life. Maybe you were a prosecutor back in the day and you made a lot of enemies putting some people away on gun charges. Maybe you just you're in the media, you're in the spotlight, you're in politics, something like that. You got a high profile. You may be able to demonstrate a special need for self-protection distinguishable from that of the general community. I would advise all of us that have clients that are looking to get their license to carry, work on this. They're going to push back. They're going to be upset. They're going to say, well, I don't really want to show that. Why do you want the weapon? Even if you could just articulate the fact that you had a break-in your home, your mother had a break-in at her home, the family, blah, 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 is on edge. We want it for self-protection. Be able to articulate why you want the weapon in the first place. If you can rise to that level of demonstrating a proper cause, a special need for self-protection that's different than everybody else, you're going to be in a very good situation, at least on that point. New York courts generally require evidence of particular threats, attacks, or other extraordinary danger to personal safety. I don't think that that's necessarily true across the board. I don't think that the New York courts generally require evidence of a particular threat. I think that it's more of a entirety of the situation approach. They're going to look at the person's background. Obviously, all those things we talked about on the front side have to be in place. All those boxes need to be checked, but then they're going to look at the big picture. When licensing officer denies an application, judicial review is limited. That's for sure. So New York courts are going to defer to the officer's application of the proper cause standard unless it is arbitrary and capricious. We all us lawyers know what arbitrary and capricious means. It means somebody explain what the reasoning was for them to rule this way. Arbitrary and capricious means it's not connected to any reasoning logically. It's just capricious. It's just kind of pulled out of thin air. That's a pretty high standard. So if the licensing official articulates any basis, it's going to be upheld. Let's see. Second Amendment guaranteed to all Americans the right to bear commonly used arms in public, subject to certain reasonable, well-defined restrictions. For all you folks that have clients that are, Second Amendment advocates across the board that say there are no restrictions, please have them go back and read the Second Amendment. I think it's always worthwhile when I tell my clients who are very pro-gun, please read the Second Amendment and then tell me what it says to you. I think that's a good place to start with some of the folks that want to get into getting a license to carry, and it's based on their right under the Second Amendment. Tell them that, yes, there is a general right under the Second Amendment, but let's look at the rights and rules and regulations in the jurisdiction in which you're trying to get your weapon. It's a much more productive, useful measure of your time. Don't worry about what the Second Amendment says, other than look at the language. Okay, it doesn't say you can carry a gun in a church or anywhere you want, and then look at the laws in the jurisdiction that you're trying to get your weapon and you're trying to get your license to carry. In New York, they make it very clear. It's right here. They spell it out in painful detail. Constitutional right to bear arms in public for self-defense is not a second-class right subject to entirely different body of rules other than the Bill of Rights guarantee. So that's what the folks were arguing, that were saying, well, wait a minute, why do we have to have all these additional regulations? Shouldn't it just be what anybody under the Second Amendment is allowed to do? The same guy who's out in 100 acres out in Idaho should have the same requirements and preclusions that anyone else does. That's not reasonable. That's not reasonable. You can't have people walking around in New York City or Westchester County or Albany with the same freedoms with firearms that you do in rural areas. It's just not something that works. It's not what we do. So we obviously, that was an argument that did not work. There is an ability by the government to say this is a reasonable restriction on your rights. It's applied directly to a purpose that the government sees. The purpose is to be protecting the citizens and to be identifying individuals who do have weapons and to be regulating and licensing them and basically supervising their possession and use of firearms under New York laws. New York's proper cause requirement violates the 14th Amendment in that it prevents law-abiding citizens with ordinary self-defense needs from exercising the right to keep and bear arms. Obviously, that argument was also something that was heard by the folks advocating that these restrictions were improper. But at the end of the day, New York says we're going to put these restrictions on people that are trying to get a license to carry a concealed weapon.
All right, Bob, I'm just going to stop for a few seconds. Give out the first course code to everyone. First course code is 725913. 725913.
Okay, the sensitive locations provision of New York law, really in line with what we've just been talking about, reasonableness, what makes sense. These are not arbitrary and capricious regulations by the government. Okay, so now we're looking at, okay, can the government say where are the locations that you can and cannot take your firearm? So here we have the New York sensitive locations provisions. This is where no matter what, you cannot take your concealed firearm, even if you have a license. So identifying sensitive locations as follows. These are where you can't, and it's a Class E felony. We're talking felony charges here. Wait, I've got a license to carry. I can't take my gun to the farmer's market over in Troy. No, you cannot. Your license does not allow you to do that. And here we go. Here's where you cannot take it. Any place owned or under the control of federal, state, or local government for purposes of government administration, including the courts. That makes sense, right? That was one of the issues that came up a few weeks ago in LA when the protesters were at the government buildings. One of the reasons that that was something that law enforcement could move in on and push those people back is because government buildings are restricted locations. They are sensitive locations in terms of New York's law for possessing your firearm. Cannot have your carried firearm, concealed firearm in any of these locations. So we're going to start with the government buildings. Totally makes sense. Any location providing health, behavioral health, or chemical dependence care or services, hospitals, clinics, things of that nature. And you can understand why. Anybody who's ever been to the hospital knows you can walk right in. No magnetometers, very little security, no weapons on those security officers. So you can't take it into those locations. And obviously behavioral health makes a lot of sense, right? So you've got regular health, behavioral health, chemical health, we're talking about addiction, substances, things of that nature. Any place of worship, we don't need to say anything more about that with the shootings that we've had in places of worship. Also, places of worship are protected places. We go there, we feel we're safe. We don't expect our fellow citizens to be carrying concealed weapons on them, and they cannot. It's an E felony, so don't do it. Any place of, libraries, public playgrounds, public parks, zoos, right? That makes sense. Children, families, people out enjoying themselves and interacting with each other. That's a place we don't want to have people who the state has issued a license to carry a weapon. We don't want them taking their 9mm to the park. So anywhere that's a library, a playground, a public school, those kinds of places, you just can't do it. Any privately held land within a public park not dedicated to public use. That's an exception, and it's been challenged. The whole privately held land within a public park. Don't worry about that. It's not going to come up, but you can see if somebody donated land to the state, and inside of that publicly donated land, there was an area. It's a rare situation. It's not going to happen very often. The forest preserve, as defined in subdivision 6 of section 90101 of the Environmental Conservation Law. Forest preserves. Now, no one's going to think of that, right? But you can't do a lot of the things in a preserve that you could do in a regular place. You can't hunt, fish, a lot of those things. So they're saying to you, a forest preserve that's defined in that subsection of the Environmental Conservation Law, you're precluded for taking your firearm there. So don't do it. Location of any program licensed, regulated, certified, funded, or approved by the Office of Children and Family Services that provides services to children, youth, young adults. Again, common sense. We don't want individuals taking their concealed weapons into locations where there are children and where Children and Family Services are providing those services to children, to the youth, to anybody in those programs. We do not want to have those kinds of facilities allowing people to have concealed weapons on them. Again, we talked about schools a little bit: nursery schools, preschool, schools, summer camps, and then they talk about the summer camps, where such activity occurs at a summer camp. Obviously, if it's a summer camp for older kids where they're doing, they're doing archery and target practice and maybe even some hunting, that's an exception. But it has to go through the proper regulation. All right. So more sensitive locations, people with disabilities, right? Developmental disabilities. So if you're going to go to a facility that's doing a program that's licensed, regulated, certified, operator, funded by the Office of People with Disabilities, you can't bring your weapon there. Same thing, funded by the Office of Addiction Services and Supports. If the Office of Addiction Services and Supports is running a program, providing services to someone, we don't want people bringing their weapons in there. That's a mix of really, really bad circumstances. So whether it's with the individuals who are actually receiving the services or people transporting them, picking them up, dropping them off, visiting. Obviously, addiction services are off the table. Funded by the Office of Mental Health, self-explanatory. Funded by the Office of Temporary Disability. So when you talk about the Office of Disability, it doesn't mean just mental health disability. It also means physical disability. So any of these programs, licensed, regulated, certified, operator, funded by the Office of Temporary Disability Assistance, if you're going there to argue about your disability check, that's not somewhere where you could take your concealed weapon, nor should you. It's an e-felony. Homeless shelters. This is something that until we did the research on this, I was actually unaware of. I know that certain domestic violence shelters would qualify, but even homeless shelters. So homeless shelters, runaway homeless, youth shelters, family shelters, shelters for adults, domestic violence shelters, emergency shelters, and any residential programs for victims of domestic violence. Again, very self-explanatory. It makes sense that the government would want to limit individuals in these locations from having a weapon, even if they've gone through all of the requirements to get their license to carry. Let's see, Department of Health again, residential settings, licensed, certified, regulated by the Department of Health. This is all about educational locations, which is much more broad than what we talked about above. This is any building or grounds owned or leased by any educational institution. So think about that. You're not actually on the campus, right? Let's say you're at the MVP arena while you're watching a game. Now that could fall under a bunch of things, a couple more that are going to come up. But if somebody is down there from one of the colleges and they're having that game there, and you're there for the college, you're there as a fan, what have you, you don't want to be bringing your firearm to a building or grounds owned or leased of any educational institutions, colleges, universities, private career schools, school districts, all the way down. You'll see public schools in there, public schools in terms of the New York City schools, right? Obviously, we have public schools all through the state, but then you also have private schools licensed under Article 101 of the Education Law. So even if they're not open public schools, if they're licensed under the laws of New York, under the education law, they count. Charter schools, non-public schools, Board of Cooperative Educational Services, Special Act schools. So anything school related, think that. You tell your client anything school related. If it's promoted by a school, if it's a summer program, if it's an event, if it's related to schools, leave your gun at home. It's an e-felony. Okay, this is a good one. This really should apply. Everybody should pay attention to this top bullet. Any place, conveyance or vehicle used for public transportation or public transit, subway cars, train cars, buses, ferries, railroad, omnibus, marine or aviation transportation, any facility used for or in connection with the service and transportation of passengers. Think airports, train stations, buses, cabs, anything that you get into or your client gets into and share space with another individual for the purpose of transporting that person and those persons that they're with from one location to another. Transport. So even if you're standing at a bus stop, let's say you're standing at a bus stop with 4 other individuals, that's a place and it's used for public transportation. So be careful where your clients take their firearm. If they're going to take their concealed weapon out on it for the night and they're going to take a bus and a cab and maybe go to the airport and pick somebody up, leave the gun at home. Okay, that's a very big category that covers a lot of locations that people don't naturally think of. Any establishment used, I can tell you what this is going to be, places where you go to drink. If it's a bar, okay. Now, if it's a bar that there used to be a split, and I don't know how definitive this is to this day. There's a kind of a split of opinion in the law in terms of what is a place that only serves alcohol and what is a place that serves food, and you might be also able to get a beer there. Okay. However, if it serves alcohol, the general rule to your client is if it serves alcohol, if it's a restaurant, even like a Chili's where you can go and have a few drinks, but the primary thing is to serve food. Don't take your weapon into a place that has a license for on-premises consumption. Because if something does happen and the client is arrested and he has a firearm or she has a firearm on their person, they could be and likely will be subject to arrest under a Class E felony because they were in a location where alcohol was being consumed, as well as marijuana. That's another one too, as you can see the bottom line on that bullet, for the cannabis law on premises consumption. So both alcohol and marijuana, if it's a hookah bar, if it's a bar, if it's just an after hours bar, clearly they only serve alcohol. Your exotic dancer locations that only serve alcohol, those are dead ringers, right? You can't take your gun in there. Okay, any place used for the performance, art, entertainment, gaming, or sporting events such as theaters, stadiums, racetracks, museums, amusement parks. So this kind of overlaps what we were talking about before, where there's a school event, but it's not on campus. This says, hey, forget that it's related to a school. You can't take it to a performance, okay? If you're in the Capital District, you can think like, Saratoga Performing Arts Center, SPAC, right? Can't take your weapon there. Madison Square Garden, no, don't take your weapon there. Giant Stadium out in the Meadowlands, don't take your weapon there. So the performance, art, entertainment, gaming, casinos, don't take your weapon there. And theaters, stadiums, racetracks, theaters, we've seen over the last few years some major shootings in movie theaters and other kinds of forums. Racetracks, museums, again, Saratoga Springs right up the street, don't take it to watch the horses. Leave your gun at home. Concerts, exhibits, all those things, gaming facilities, video lottery terminal facilities, anything that has any relationship to gaming is obviously something, because gambling is something that is considered somewhat of an area where trouble can find itself. So don't take them there. Any location being used as a polling place, right? Does that make sense in 2025? Yeah, I'd say so. Do not take your gun to the polls. Do not take your gun, whether you're an independent, a Republican, or a Democrat. Don't take your gun to vote, please. Any public sidewalk or other public area restricted from general public access for a limited time or special event that has been issued a permit for such time or event by a governmental entity. You guys know what that means. That's one I had to think about a couple times. Again, the Troy Farmers Market, right? You come to some area, there's a bunch of gates. Think Times Square in Manhattan, gated. It's all gated off. It's, the NYPD or the Albany PD has got this all marked off. That's an area where you can't walk over that barrier with your firearm. That is a public area that's now been restricted from general public access. So you have to be very careful to that. The caveat is that those locations must be identified by clear and conspicuous signage. Okay, so they can't just block it off and then wait for people to walk over that barrier and then frisk them and find out that they have a weapon and charge them. It's got to say, no weapons allowed beyond this point. Kind of like when you walk into 100 Center Street, the main courthouse in Manhattan, it says no weapons beyond this point. Think of it that way. That's what should be there. And just don't take it over any of those locations. Any gathering of individuals to collectively express their constitutional rights to protest or assemble. That kind of ties back into the earlier point when we talked about the LA protests where they were at government buildings, right? If it's a protest and people are gathering and assembling and exchanging views and expressing their views, which aren't going to automatically all line up with the guy next to them, right? Those places you cannot have your weapon, because it could be a conduit for trouble. And unpleasantness could ensue if you bring your weapon to places where people are protesting or assembling and talking about heated issues. This is a great example. The area commonly known as Times Square, just talked about it with the barriers, right? As such area is determined and identified by the city of New York. And again, it needs to be clearly and conspicuously identified with signage. So those are the top sensitive locations. We still have about 6 minutes. I'm going to run through them. These are just all of the requirements. Again, social media accounts and law enforcement's capacity to follow up. You have to meet in person. We talked about that. You have to give them all the information. You have to be honest. Give them everybody you know, everybody you live with in your house. That's very important. They want to know whether the minors are going to have access to weapons, or if there's anybody in the household that's an adult that has a criminal record and may have a prior weapons offense. You know about your 4 contacts. your training requirements. And I think that's pretty much it for that. Now, red flag laws. That's a very important section. I'm sure most of the attorneys on this presentation know about red flag laws. We're talking about ERPOs, right? Extreme risk protection orders. A extreme risk protection order comes out of these red flag laws, which basically is trying to protect communities against gun violence. They're used to say that, listen, if I know somebody has a weapon and they're arrested for a charge where they evince an ability or a mindset to cause themselves harm or harm to someone else, they can have what's called an ERPA, an extreme risk protection order, filed against them by the court, which means they can't have their weapons. Their weapons are confiscated and held until they have their hearing. At the hearing, they have a choice to either go forward and contest or basically say, yes, I did make that threat, and the gun can be held away from them for a period of time. We're not going to get into a lot of that. We don't have a lot of time on that, but just know that if you have a client that has a weapon and you find out that they have some kind of mental health history, or they've made a threat, or they've been arrested for a domestic violence charge, a harassment, a menacing, anything like that, stalking, anything like that, your client is going to be subject to an extreme risk protection order, which is going to take his weapon for a period of time until he can demonstrate to the court's satisfaction that he's not, or he or she is not a threat to himself or the public at large. I believe that's our last slide, Brittany. Let's flip it one more time.
Yep. I just got to give out the second course code for today. It is 539021. Against 539021. I will keep it on the screen for a moment, and I will start collecting the questions that were received. All right, we have a few questions that came in. We'll answer as much as we can in a little bit of time that we have left. So it looks like in the application license, can an agency see guardianship cases and medical records, or do we need to provide them?
Well, you need to provide them. They're going to ask you for that documentation. In terms of their ability to obtain that, I don't know what their tools are for obtaining that, but this is my advice. If the licensing official asks you for a document or information, provide it, because they're the ones who make the determination. And then if you don't provide that information, they could simply deny you on that ground and say, well, we asked for information, they didn't provide it. Denied.
Can you comment under the circumstances where weapons are considered in plain view for a doctrine that a police can often, and even when not in plain view?
Well, the plain view doctrine is not something that applies in New York. Plain view is a doctrine that's applied in some of the other states in the South, out west, in rural areas where it's acceptable to have a weapon in plain view. It literally takes, in those jurisdictions, it takes the place of the license to carry concealed, because what we're saying in those jurisdictions is we don't want you walking around with your GAC strapped to your hip, right? We want you to kind of keep that on a low key. In those plain view jurisdictions, they're not saying that. They're saying you don't have to keep it undercover. We're out here on the range. We're out here in Texas or Oklahoma. We have plain view. You can carry your weapon in plain view. That puts everyone else on notice that you have your weapon. But that's not applicable in New York.
Does a parking lot of sensitive location count as a prohibited place?
Yes, you would want to consider, because the parking lot is going to be either controlled by or paid for, or at least in some way, shape, or form connected to the sensitive location. So yeah, unless you're parking across the street and walking a distance to the location, I would consider any parking lot next to or used by a sensitive location as part of that sensitive location. And law enforcement will too.
In New York State and New York City law, assuming eligibility requirements are met, a New York City resident may possess at home, and not carry a shotgun if he or she has a shotgun license, and if the New York City resident may not possess at home, not carry a handgun without a license.
So I'm not sure I understand the specifics, but the city of New York laws obviously are much different than the state of New York laws. Now, in terms of the New York City resident, they're going to have a license to carry that's going to be specific to that weapon. Now, if you have long gun permits, or those guns are legal under New York City limits, that's a different section of the law. If you're talking about your permit to carry in New York City, that's one of the highest, most regulated areas of gun possession. So you'd have to look specifically, what are the weapons? What are the long guns? Are they regulated by any of the city specific requirements or restrictions? Or does that permit that person have cover whatever those weapons are that are in his possession? I know that's not a great answer, but New York City, you've got to check almost on every 6 months, check the rules and regulations in New York City. Apply those specific weapons to that reg and that permit.
How do you get back your weapons, which you physically surrendered in order for an order of protection, either from a family member or criminal court, has expired?
Once it's expired?
Yes.
After it's expired, you basically just need to make an application to the court to say that the order is over with, there's no ongoing threat of harm. And then the district attorney will either oppose or take no position on that request to have your weapons returned to you. So once the case is over with, if there's any underlying charges, those have to be resolved. The disposition has to be over with. And then if there's no ongoing threat to the person who had the order of protection in their favor, you can petition the court to have your weapons returned at that time.
Can you comment on the fact after the portions of the law that were declared to be unconstitutional of the number of law enforcement agencies publicly stated that they are not enforcing as much of the sensitive locations restrictions other than the other parts of the law?
Yes, that's right. That's correct. The law enforcement officers, again, this is kind of a subjective area. They are going to use their best judgment in terms of making an arrest. If someone seems reasonable, but they're in a sensitive location, they may just say, move along, they may just let it go. There's a lot of subjectivity in the law enforcement's eyes in terms of what they determine is in fact a violation, and that's why the regs are written that way. They're written in a vague way to give the licensing official or the investigating authorities, if they think there's been a violation of those regs, a lot of latitude. And the officer involved or the licensing official involved is going to use their percipient senses, what they see, what they hear, what they sense, what they understand, to make a determination. Does this person qualify, and should they get a license? Has this person, although they have a license, are they violating the conditions by carrying in a sensitive location? It's very fluid.
We have another question about the parking lot question. Can you keep the firearm in the locked car if it's not on yet?
Well, any firearm in a locked car should be broken down and should not be within the reach of the individual, first of all. So you don't want to have it under your seat or in your glove box where you could just pop it, grab it, rack it, and shoot somebody. That's not going to be good. But to your specific question, if that parking lot is part of a sensitive location, if it's outside a church or a hospital, don't put it in the glove compartment. If you have to have the firearm with you at that location, put it in the trunk. That way it's really not technically in the passenger compartment of the vehicle. It's in the trunk. Now, that's going to prevent any officer from saying you have easy access to that weapon in that sensitive location. You'd have to get out of your vehicle, go get it in the trunk, put it together, load it. So that's how you can avoid that kind of an offense causing you trouble.
Okay. We'll do one more question here and then we have to wrap it up as we are about 5 minutes over the time. What applies if an owner's home is in Times Square or some other sensitive location? Can a gun owner possess, including transport to or from a gun in that home?
Anyone who lives in Times Square is going to have to have an exception to that rule. So they're going to have to go to the authorities in Times Square and talk to the good folks in blue about how to go about bringing a firearm into and out of a sensitive location designated by the city of New York. Obviously, there are people that live in that location, whether they be, you know, whomever, government people, other people that do in fact have weapons and do transport them from their home in and out of those locations. However, you're going to have to make sure that that's all greenlit by the authorities. The authorities are going to tell you what you can do and what you can't do. Check with them. Whatever they tell you can do, do it. And if they tell you something that you're not happy with, try to find a way to appeal. Try to find a way to get a different ruling. Thank you, everybody.